Here, here.
I believe everybody's done a really great job of thanking everyone here. I'd like to thank you for some fine competition. I'd like to especially extend thanks to my coach, Pete Bone, and to my partner, Alan Tower, without whom I truly would not be here, and has been a colorful debating history, to say the least. With that, I'd like to begin by looking to the resolution, and I'd like to plant a seed in your mind begin when you think about three strikes legislation. And it's an argument that hasn't really been presented in this debate, although we did want to raise this in a point of information. And that is the fact that the three strikes legislation that they talk about was the result of a referendum process within California. It was the will of Californian voters. And I believe that it is the burden of the government team in this debate to show you that a jury's justification overriding the will of the California voters, it is justified. That they have the right, not only the right, but that they actually can justify the warrant for the juries to override what was a true referendum process by the people of California. And I want you to keep that in mind as we first begin by looking to the idea that Chad gives you that paramilitarization is key because we're only talking about this specific contest. First, I believe he's missing the argument that was the answer here, and that is the first fact that we basically say that this case sets a precedent. And that's the kind of precedent that opens the door for the arguments that we give you off case. That being the fact that it basically it leads to court clog and undermines the rule of law. The reason this is true is because it sets a precedent. When juries are able to do something that courts traditionally find unethical conduct of lawyers, which can be disbarred, you set a very dangerous precedent that does undermine the rule of law and leads to the kind of court clog that we talked about. And with that, I'd like to begin by looking to the court clog disadvantage. Now first, the idea that we talk about is the very fact that 95% of these trials result in a plea. He states that the appeals process actually makes the clog worse, but this is empirically not true. And the reason being is that the appeal process is one person taking a case to the court that would result in sufficing for 100, if not more, single trials. The appeal process is actually more efficient in metering justice for each individual because it takes one case instead of 1,000 cases where the jury renders this decision. Not at this time, Chad, I gotta really get through this. Basically, the Supreme Court rules for many. That decreases the clog. That proves the fact that one appeal process would be a better way to go. He states next that this is just justice denied, but he doesn't tell you how. How is justice denied when we can prove to you that the appeal process actually brings justice to a greater scale, justice to more people, if you will? And I'll pause for your question.
What is the contention that is going to happen in the appeal process, either at the intermediate court or at the Supreme Court? That the three strikes law is going to be overturned, or that individual conviction will be overturned?
The idea is basically that instead of having the jury rule on one individual person's case, what you can do is go through the appeal process in order to have the entire law revoked, the entire process, the entire referendum ruled unconstitutional. That has a more overarching and comprehensive effect on society. Furthermore, I'd like you to extend some of these arguments that right now we see court clog in the status quo. So anything that makes this problem worse is a reason to reject their interpretation. Next, that judicial nullification increases the likelihood of going to trial. That's what uniquely means that you're going to have more clog in the system. That leads to a cumulative effect where more people see an incentive to go to trial, that overloads the court, and that is the net decrease of justice that we talk about. And he's really not taking issue with that cumulative effect, that it does tend to snowball. One person sees a success in court, they decide that it becomes a new incentive for them to do it. That's justice delayed, and that's what makes it problematic. Let's move on to the rule of law. And that's the fact that we tell you that juries are key to the rule of law. He says what's really key is recognizing the act and intent, and right now the system neglects intent and violates this unconditionally because the three strikes laws are abusive, and it's jury's duties to fix that. First, what about the duty to the victims? This is a one-sided interpretation of what justice is, not at this time, Chad. It tells you that what the jury should consider is the plight of the offender. The jury should consider the justice of the offender. Nothing in this interpretation that the government gives you provides a balance of justice. It provides a one-sided interpretation of what justice is. Now, we tell you that these harms that they elucidate about the problems that exist in the criminal justice system are really non-unique to three strikes. That the very racist and nature of the criminal justice system applies widespread through it, not just three strikes legislation. And basically, jury nullification is not key to ending those processes on one level. It's key to confronting them, or what is key is confronting them on massive levels. And that's doing things, sorry, not this time, Chad, like referendum processes, like appealing to have greater symbolic action. And I want you to extend the fact that this is really unanswered at the bottom here. And that is the fact that having this rule of law is key to a stable, democratic society. That we saw very recently with the Bush v. Gore decision that we can have a stable transition when we respect the rule of law. When you basically allow for the acquittal because of the double jeopardy clause, you let somebody off for good. There is no retribution to the victim because we can't try these individuals ever again. And that's problematic. We can all reference potentially OJ on that one. I'll take your question here.
Is it your philosophy that three-strike laws are just or unjust?
My philosophy is that people ought to have the right to participate in the way that laws are metered in society, and that a referendum process reflects the will of those individuals. I may disagree with it. If it came upon my ballot, I'd certainly vote against it in my state. But the will of the California voters to be overridden, you need to prove that there's some reason, some moral reason, or some empirical reason to do that. Now onto the case today. We tell you that California is the only example that jury nullification is wide-reaching, that it expands elsewhere. That's the precedent that we're talking about. He says lawyers don't have to suggest this, and it's not going to help these individuals that are sitting in jail. It's the act and intent, again, that he's reiterating that is key. No, there is no propensity for this to happen. Where is the justice that is not one-sided? Where is the justice for victims again? He just tells you, well, that basically isn't all as important as overturning three strikes laws, but where is the warrant for that argument? The act and the intent is key to interpreting what is justice for victims as well. That's the reason that we have offender mediation programs, not at this time. That's the reason that we have trials to meter out what is a fair sentence that not only meters justice to the offender, but also to the victims. I'd like to look to the next turn here. That was that jury nullification increases the inconsistency of the law. He says, well, that doesn't matter, but he misses the analysis. Here I have to hope that my jury is going to nullify the law. It's not giving each their due, it's giving a little slice of someone's due once and again, maybe depending on whatever the jury decides. That's not justice, sorry, not at this time. The next turn, that there is no justice for the victims. He says, well, we're not talking about felonies. That's empirically not true. The three strikes law is about felonies. It is not misdemeanors, only it is felonies. And it's felonies that allow you to be able to shield your history, that allow people to not know necessarily what your past is. That's problematic. Please extend the turn. Sorry, I got a lot to get to, Chad. Next turn, and that is that it increases the tyranny of the majority. He says that's not the case. It's really the tyranny in the state legislature. No, actually this is empirically denied. And the reason being, look to the examples of hate crime legislation that we give you. Juries would have the opportunity to deny portions of sentencing that would allow them to impose a harsher sentence because of hate crimes. You deny the opportunity for juries to do this if they can make this, you provide the opportunities for juries, sorry, not at this time, to make that a wash. They don't have to consider that sentencing if they don't want to. That undermines the will of individuals who put that on a referendum process, who lobbied for that, who pushed for that. That's problematic. There's no justice if the jury doesn't follow the law. Next turn, the criminal justice system is racist, but we can't guarantee that doing what they're suggesting is going to change this. He says it's really that the juries can solve, but he doesn't tell you how. How are the juries going to solve for any of this racist nature? Next to the next argument here, that this divorces the ability to consider other factors, this intent argument again. Often we don't know because defense attorneys can shield your information as a jury member to background information. He tells you, well, the judge will be able to consider it. But no, it doesn't affect the jury's decision. The jury's decision is contingent on all the information. If they don't have all the information, then maybe justice won't be metered for the victim. In fact, it's less likely it will be metered because they don't have all the background information. Legislatures, the Supreme Court, movements are better ways to solve for this problem. Next turn, that is the idea that there's no justice because there's no sentencing with no punishment. He has no answers to this. I'd like to extend this case turn. And the impact of it is that there is an unequal amount of justice. It's not justice for each due, it's justice for the offenders. There's no solvency for this case. They don't solve in the first place on an individual level, and they undermine people's will.